I'm the General Counsel at Creative Commons, and I handle most of the legal questions that come in, responsible for stewardship of the licenses. And one of the things that we've had to grapple with over the past year and a little bit more is, what is the Creative Commons going to do about AI? And it's interesting that people are looking to Creative Commons for answers to these questions. What is open in a world with AI? How do the licenses work in a world with AI? What is the situation with training, both on open materials and closed materials? And the outputs, are they copyrightable? Who is the author? Does it even matter? What is the law around those questions anyway? CC's been exploring those questions over the past year. For those of you who read the CC blog, you may have seen us we've written a lot about some of the legal issues that we've explored. We've done some community consultations, and we've been looking into how that fits into our mission of better sharing. CC is best known for its license suite, but we're not just a copyright license-focused organization. Our mission is to reduce legal barriers to the sharing of knowledge. How does AI work with that? What kind of world are we creating? We've brought together a group of experts to address some of the legal issues from a few different perspectives. And I will say that part of this presentation will be in Spanish, and thank you, Carolina, so much for offering to translate. But I'm going to let everybody speak for themselves, to introduce themselves, their name, their affiliation, and a little bit about how their work intersects with AI.
Thank you, Kat. My name is Teresa Nobre. I'm the legal director of Comunia. We are EU-based civil society organization working to defend and expand the public domain and users' rights. And we were deeply involved in the latest copyright reform, which turned out to give us in the EU some exceptions that allow the training of AI, generative AI models, and I think that's where our interest now lies. And of course also the questions of the protection of AI outputs, but that's a less relevant question right now. Thank you.
Hola, mi nombre es Patricia Díaz, soy abogada de Uruguay, coordino una organización que se llama Laboratorio de Datos y Sociedad. DATISOC, formo parte del capítulo de Creative Commons Uruguay y trabajo junto con varias organizaciones de Latinoamérica en la Alianza Latinoamericana de la Sociedad Civil por el acceso al conocimiento.
Hi, I am Patricia Diaz. I am a lawyer from Uruguay. I work at DATISOC, and I am also part of the Alliance for the Just Access to Knowledge in Latin America.
Buenos dias, me llamo Ryan Nishimoto, and that is the limit of my Spanish. I am a partner with the law firm of Arnold & Porter. I am based in Los Angeles. My practice is focused on intellectual property and primarily litigation, which includes copyright, trade secret, trademark, and patent cases. But the more interesting part of my practice is advising clients on emerging technologies and the intersection with the law. Often emerging technologies outpace developments in the law, as we are seeing here today with artificial intelligence. And so that's hopefully what I will be able to focus on today and bring to the table in my small way.
Thank you. Good afternoon, everyone. My name is Nick Garcia. I'm a policy counsel at Public Knowledge, which is a nonprofit, nonpartisan consumer advocacy organization based in Washington, D.C. For our part, our mission is dedicated to protecting free expression, promoting an open internet, and affordable access to creative works and tools. How I fit into that is that for me, that means that I do a lot of work on promoting net neutrality, an open internet, intellectual property reform, and most recently and most actively, I do a lot of our work on emerging technologies, especially artificial intelligence, and its intersection with those areas of our mission.
I'm James Grimmelman. I'm a law professor at Cornell University. I teach technology to law students and law to technology students. And in the past year, both groups have come to me very interested to understand more about AI and law. The technologists want to know what the legal environment the things they build will operate in, and the law students want to understand these technologies that seem likely to change almost everything about how they work.
So we've heard generative AI called both one of the most revolutionary technologies since the internet itself, something that might bring, and some people calling it a fad that will probably go away in a few years. But most of us have had our daily work changed in some way by the introduction of generative AI. So I want to ask, how has the introduction of generative AI affected your work, and particularly the community and the people that you work with? And I'm just going to go down the line with this one.
Okay, so as I was saying, I mean, not so much my work, but we have legal concerns, or our communities have legal concerns, and those stem from the existence, and I think that's probably unique in the world, of a legal framework that supports the training of generative AI through exceptions to copyright. And this legal framework is mandatory in Europe and consists of two exceptions. One that would allow you to mine and scrape and train AI for scientific purposes, and another one that is a more of a general purpose mining exception that would fit the kind of reproductions, copying for purposes of training generative AI models, namely by commercial entities and for commercial purposes. And so there's been a lot of discussions in Europe, mostly around this second general purpose exception, because this exception, well, it's quite unique in Europe in the sense that allows mass-scale uses of works, copyrighted works, for commercial purposes. And because it's so unique, the lawmakers put some thought into it when they were designing it back in 2018. And this was approved in 2019, a few years before the explosion of generative AI. So generative AI was not really into their minds, but it so happened that they drafted and designed the exceptions in such a neutral way that it does cover the type of training that we are now seeing happening. So, as I was saying, because it's a kind of novelty for Europe to allow this kind of commercial uses by commercial entities without the permission of authors, the lawmaker introduced two main conditions to make it a more balance in terms of the interests of creators and the interests of the commercial entities that would benefit from the exception. And these two conditions are lawful access to the works and the possibility, and I think this is the big thing, the possibility that creators have of opting out of the exception. So I think our main legal concerns right now and discussions in Europe are around these two conditions, and especially because there's no transparency in the AI development. So there's a discussion on, creators are claiming they are not able to understand if their works are being used by generative AI, and they are also not able to right now understand what's kind of the effective way of reserving their rights, so of opting out of generative AI. So these are kind of the main questions that we have right now, transparency and how to effectively opt out. And so these are our concerns.
Bien, el tema de la inteligencia artificial en Latinoamérica, más allá de la inteligencia artificial generativa, no venía siendo un tema desde el punto de vista de los derechos de autor. Sí, obviamente, en muchas otras áreas, principalmente temas éticos y principalmente el tema de tratar de desarrollar nuestro potencial latinoamericano, porque estamos atrasadísimos. De hecho, el BID ha publicado datos de que somos el continente que tiene la proyección menor. Y le paso acá.
She has too much faith on me. So artificial intelligence has not been really much discussed in Latin America from a copyright perspective. Has been an issue on topics such as ethics, for instance, and most importantly, from an economic point of view. The Inter-American Development Bank has, for instance, given some figures that show how Latin America is lagging way behind other regions of the world on the topics of economies of artificial intelligence.
Y otra cuestión que tenemos que entender desde la mirada latinoamericana es que no tenemos un régimen nacional relacionado con excepciones y limitaciones al derecho de autor en ningún país de Latinoamérica. Después lo podemos discutir en profundidad. Tampoco tenemos un régimen de armonización de reglas como tiene Europa. Por lo tanto, el foco hasta hace poquitito era tratar de modificar las leyes para lograr apertura, para generar posibilidades de utilizar datos legalmente, con al menos investigación sin fines de lucro.
The other issue that has to be taken into account is that national laws or regulations do not have an exception system in Latin America for these purposes, nor there is a harmonization system such as in Europe that the countries can rely on. Therefore, what we have been seeing is a push at least to be able to use these kind of techniques on the research, for research purposes.
Y ahí viene y entra en el escenario la IA generativa. Es un problema para aquellos que estábamos intentando generar flexibilidades al derecho de autor. De hecho, al menos conozco que hay iniciativas en 2 países, en Brasil y en Uruguay, para reformar y incluir una excepción para análisis computacional que incluya cualquier tipo de análisis computacional, incluido text y data mining, creación de datasets de entrenamiento, etcétera, con fines de investigación sin fines de lucro. Hasta ahora la intención es esa. Pero la IA generativa es una piedra en el zapato, es un escollo a superar porque ahora sí se está mirando esta regulación.
Uruguayans talk a lot. This was the case until generative artificial intelligence is now on the map. The issue with this is that it has become, it's problematic from the point of view of the people that was working for exceptions and limitations for research. Basically now there are at least 2 countries, Uruguay and Brazil, that are looking to do a copyright reform to include a much broader exception and limitation that would include, in general, computational analysis, and I forgot the techniques. Okay, all the techniques around computational analysis.
So the question was broadly artificial intelligence and why am I here? And what issues am I dealing with? As a lawyer in private practice, what I do is driven by the questions that come across my desk from clients. And part of my job is to anticipate what those questions are going to be, because quite often it's hard to tell, especially in the area of emerging technologies. And so for the past 4 or 5 years, questions have increasingly started to focus on the legalities that are implicated by artificial intelligence, and primarily copyright. Because copyright law doesn't necessarily anticipate everything, and so what we do is we dust off laws dating back to the 1970s. And again, I'm US focused, so I have a myopic view on US law. And I appreciate some of the perspectives on Latin American law especially, because those questions come across my desk as well, and I'm so often at a loss. I don't know the answer to that. But from a US law perspective, the questions come from any number of clients. And what's fascinating to me is the broad spectrum of clients. that have these questions. You can imagine, of course, the content-based clients, those that create content for the world to consume, both profit and nonprofit. Also on the tech side, folks that are looking or dealing with questions of AI and how to develop these platforms to avoid what they anticipate would be copyright issues 4 or 5 years down the road. This is back in 2018 and 2019, and now here we are seeing that come to fruition. And if anyone follows any of the litigation, you'll see a host of litigation crop up in the United States on these very issues against the very tech industry. I'm happy to say none of whom are my clients who have been hit with the copyright infringement suits. What's also fascinating are the non-expected players. So those who aren't content producers, aren't traditional tech companies that would play in the AI space, but those whose work suddenly intersects with implications from artificial intelligence. And really this goes back to questions that we were dealing with 5, 6, 7, 8 years ago. Remember back with the Facebook debacle when it came to light about all of the data that Facebook was gathering from all of us and then monetizing and selling off for profit. And it really exploded in public view in terms of privacy concerns and the implications of that. The point I'm trying to make here is any company that gathers data, that has data, is sitting on a potential wealth of information. And so you've got clients now that are looking at how to use this wealth of data that goes all the way back in time to any sort of social media platform, any sort of data scraping issues, anything where there is a massive data now, and what are the implications of that? I know I'm getting a little ahead of myself when I talk about privacy issues, but those questions are yet to be wrestled with. And so in terms of artificial intelligence, I think we've just begun to scratch the surface in terms of what the issues are.
I'm going to pick up on some of the same themes as Ryan here. So working in tech policy in Washington, D.C., up until recently, when you mentioned AI, people were thinking of the keywords that people were thinking of before used to be big data, was what people were talking about 5 or 7 years ago. And then that conversation morphed as we began to understand more about how that data was being used into being about algorithmic accountability and algorithmic justice, discussing issues of bias and fairness, very similar to what Patricia was talking about as how a lot of the conversation has been in Latin America. And for a while, that has been the locus of conversation. The big change with generative artificial intelligence in our work has been all of a sudden that intellectual property, and copyright especially, has exploded onto the scene as being more relevant than ever, in people's minds at least, in terms of how we think of artificial intelligence and machine learning technologies, and people trying to grapple with how we think about the inputs into these systems from a copyright and intellectual property perspective, as well as the outputs from these systems that seem to challenge our notions of creativity, of human authorship, and then most especially that create questions of economic displacement. And our perspective has always been that copyright is an economic system, but it is not a jobs program. It is not a social welfare benefit net in order to protect people. So we need to be separating out questions of labor and economic displacement and thinking through serious policy considerations for how we address those in a holistic way, while at the same time being really smart about how we view the future of copyright and of intellectual property in the context of generative artificial intelligence. So now the AI question is starting to cut across many of the things that we care about at Public Knowledge. It's cutting across questions of free expression and the relationships with the platforms. It's cutting across questions of accessibility and justice, which relate to our work closing the digital divide and trying to bring broadband and connectivity to people. And it's now also cutting across our historic work on intellectual property and ensuring that people have robust access to creative works and tools, including AI ones. So it's been very interesting in the past year seeing how this technology has moved into all of these different sectors.
In my case, a lot of my work over the last decade and a half has focused on sort of bulk uses of copyrighted works. So starting with the Google Books project in the 2000s, when Google was scanning millions of books and was sued by authors and publishers, I've been very interested in any uses that involve machine analysis of human creativity. And that raises very tricky issues because on the one hand, it looks a lot like the copying that triggers copyright, but on the other, machines don't consume and experience creativity in the same way that humans do. And so in the United States, we had a series of cases, primarily, but not only the Google Books case, that seemed to use our very flexible fair use doctrine in a way that settled on a conclusion that machine uses were legal as long as the content went in and was not then leaked out. So that building a gigantic repository of books for free sharing would trigger copyright, and that was the file sharing lawsuits. But training an AI model on a lot of different works would be transformative and wouldn't compete in the market with the original author's works. And so this seemed to be a kind of compromise that the system settled on. The arrival of generative AI has really unsettled that, because now you have systems that are trained on creative works that produce outputs that themselves are creative, that are meant to be experienced as aesthetic experiences by humans. And some of those are very different than anything they're trained on. Others are very similar to training works. And that possibility that the outputs of generative AI are not just in some separate technological sphere, but are coming back into the cultural space that people use and create copyrightable works for, unsettles the legal compromise. So I've been trying to pay attention to both the litigation over the legality of training AIs and also how we treat the outputs as cultural products. There are some artists who feel very strongly that AI creativity is not creativity. It's not really art, that art comes only authentically from humans. And there are other people who think that anything that is pleasing to listeners and audiences, that audiences enjoy, qualifies, and that therefore machine creativity is no different. Both of these traditions have long roots in the United States copyright law. And so there are arguments you can make within the copyright tradition for protecting the outputs of AIs and arguments you can make against it. So those are also being heard at the Copyright Office, which is receiving applications to register works that were generated in substantial part through the use of, right now it's visual AIs like Midjourney and DALL-E, but I'm sure that all kinds of works in many media will show up there in the near term. So we're trying to keep up with the immediate doctrinal questions that are coming into the courts and the Copyright Office, because when somebody files a lawsuit, you have to have an answer now. At the same time as a lot of the players in the system are trying to think about the longer term policy challenges, the Copyright Office is conducting a study right now about what changes to copyright law might be needed due to generative AI. And it's not clear that many people have a really thoroughly thought out vision for, here's the language we should put in the Copyright Act tomorrow. There are conversations that are ongoing and many groups are weighing in with thoughts, but the policy conversation is still at a very early stage.
Teresa, I think you had more to add about the policy situation in the EU.
Yeah, I mean, just to clarify, we are not a general digital rights organization in Europe, so we do focus just on copyright. That doesn't mean that the concerns or the discussions in Europe are just focusing on copyright. So definitely we are discussing or in the Parliament and right now in the Council, they are discussing a regulation of artificial intelligence that deals with all those issues of AI applications that that have a risk to cause harm to safety, fundamental freedoms, etc., and ban practices such as subliminal manipulation. So there is a wider discussion going on in Brussels. Our organization is a copyright-focused organization, therefore we are just looking at those issues. And like you, Patricia, and in Latin America, I mean, I think we are very glad that we managed to pass our text and data mining exceptions back in 2019, because we are also seeing that pushback, right? So although we just, I mean, 2019 was 5 years ago, or 4 years ago, we are seeing a pushback from right holders to those exceptions, especially not so much the scientific research exception. That's quite acceptable. It's a public interest. No one is really making a fuss about it. But in terms of the general purpose that allows exception, TDM exception, that allows commercial entities to do this kind of mining and scraping without the authorization of the authors, there is some pushback, and we understand this pushback. I think we have identified why people are unsatisfied with the current situation, and I think our focus right now is just making sure that the exceptions work, that the opt-outs work, so that we can uphold this system, which for us puts us in at least in terms of balancing everyone's interests, puts us in what I consider to be a better situation that the countries that are relying on fair use and are unsure of what is permitted or not, and where creators are really unsatisfied because they cannot opt out of the system. So I think we kind of managed to get into this sweet spot where, for public interest, we have protected all uses required for creating generative AI and doing machine learning. And for commercial uses, we arrange this solution that for me and for us sounds quite balanced. So we do want, and we are making efforts to kind of support creators in a way, and trying to find ways with policymakers to ensure that their concerns are heard in terms of not being able to opt out. But yeah. Just to let you know that this is a much wider discussion, and similar to you, there is a pushback, and that's where our efforts are to hold the fort.
A very brief comment. Quería también agregar que la razón por la que hoy en realidad tenemos hasta miedo en cuanto a la regulación, las personas que trabajamos por el acceso al conocimiento y la reforma al derecho de autor en Latinoamérica, es que la inteligencia artificial vino como un problema laboral en Latinoamérica. Como un problema, pero además un problema laboral no definido, en el sentido de que estamos en el hype de la curva de Gartner y hay una sobre expectativas sobre qué problemas laborales puede generar la inteligencia artificial generativa, y el miedo es que no solo que no se regule y no se generen excepciones y limitaciones, sino que se utilice el copyright, el derecho de autor, para regular cuestiones laborales.
So there is a fear, she's going to do the comment, and there's a fear that this not only that the new reform that artificial intelligence is created comes not from the copyright side, but from a laboral side. Because in Latin America, artificial intelligence arrived as a problem of labor and the fear of people on losing their jobs, basically. Therefore, the problem right now is that there will be two dimensions of the situation. One is the issue of expectatives. How much the artificial intelligence has generated some expectatives that will not be or will be accomplished, it depends. But on the other hand, the fact that copyright could be used further from its intention to regulate what is really laboral relations. Yes. That's it.
Great. So we've seen all our panelists address the issue of inputs a little bit, and Often when we talk about the problems of AI, it's useful to separate like the problems of input on training on data, a lot of which was trained on data where people never expected that it would be used for that purpose. They may not have given permission. And of outputs, the works that were created from that. So let's talk a little bit more about inputs, like, and this trains on like pictures, texts, data sets. Like, what are the biggest legal issues that you're seeing? And I'll start down with Nick.
Great. So when I think about inputs, we like to we separate inputs and outputs, and then we further break down inputs in my analysis when I think about this. And so I like to talk about the inputs in terms of the creation of the data sets, in terms of whether there was scraping and how that data was collected, and the nature of the data sets is one issue. And then there's the issue of taking those data sets and using them to do machine learning training and analyzing whether or not there is a copyright issue there. And so to take it in reverse order for a second, when you have a data set and you are using it to train a machine learning model, you have at most a very transitory usage of any of the individual works in a very, very large data set that composes billions of things usually. And at the end of this process, you wind up with a set of mathematical weights that are not all-encompassing of the different things that went into that training data set. You have this distillation, this learning process at the end. And so it's very difficult to look at that and see that in some way there's a derivative work there, or that there's a copying of any of the things in the data set once you've done this training process. So starting from that perspective, it looks to me like when you're doing machine learning training from a fair use or from a just general copyright perspective in the United States, I would say that you don't have an issue of copyright on the training itself, the training process itself. But then when you take one step backwards down that chain and you're looking at the data sets, that's where I think it starts to get a little bit fuzzier and a little bit more interesting. And James was talking about this a little bit. You start to think about legal precedents like Google Books, where it seems like right now the settled answer is that composing things into these large data sets should be transformative uses that are protected. That any one of these individual works, even if they're copied in their entirety in these data sets from one very small part of this data set, and the ultimate function of this data set is something very different from the original purpose or function of the original work that's going into that data set. So I think at that point in the analysis, we're also should be on pretty well settled ground in terms of what those data sets are and that they are fair from a copyright perspective. But obviously, as we're now seeing the uses of those data sets in training generative artificial intelligence, that status quo is being disrupted. And we're going to see some interesting outcomes potentially in the court cases and the litigation as people are looking at these questions more closely. But I think something that's really important to keep in mind there is that many of these problems may be curable in terms of if what people are getting hung up on is the fact that there are things that were infringing when they were put into the data sets or when they were collected, that's a problem that can be fixed. That's not fatal to generative artificial intelligence. That if the problem is that the data sets aren't composed of things that people intended to share, that's a problem that's fixable potentially, as long as you can still get data sets that are sufficiently large to do the machine learning training. So that's not fatal to generative artificial intelligence. So I think people need to really break down those input questions and see if they can figure out where there's an actual problem, and then think about what those solutions to those problems might be. And I think there's good ones at every step of the process, both for ensuring that we're going to continue to have innovation in artificial intelligence training and having generative AI around for a long time, and that means it's going to be something that we have to grapple with.
And Ryan, I know you deal mostly with commercial clients. It's a complicated enough issue when people have simply released their works not expecting to make money from them, but I know you deal with people who are expecting to make money from them. Do you see different concerns?
I have not yet, but I want to hit on what Nick just said, because I think he hit the nail on the head when he said the questions of transformative use and the questions of use are going to be issues that are going to be front and center when it comes to generative AI. And for those of you who are following copyright precedent, you'll be familiar with the Andy Warhol decision earlier this year, where the majority on the US Supreme Court took another look at that first fair use prong of the nature and purpose of the use and found that there was an infringing use and that fair use was not a defense to the Andy Warhol's Foundation's use of the Andy Warhol silkscreen print of Prince based on a 1981 photograph by Lynn Goldsmith, who was the other party in that case. And the reason I bring that up is the Supreme Court really, the majority writing for the Supreme Court really emphasized that this has to be a case-by-case analysis of what the use is, and disregarded any testimony and factual expert testimony about the purpose of the original artwork. And so the Andy Warhol Foundation had put in a lot of evidence about what Andy Warhol had intended by creating that that orange print of Prince. And the court said, that's not relevant here. We are not here to sit as arbiters of what artwork is. We are not competent to do that. Our task is to look at what the use is and whether in the context of fair use that is fair. And so the takeaway from that, in my opinion, is that suddenly we now have questions that are not tied to the specific product, and in this context, whatever the generative AI puts out, but how that product is then used. And so, of course, the implication is, in one instance, you could use something created by AI and it be fair use. And you could use the exact same output in another context and be infringing and not have fair use accessible to you. What's also interesting to me is the split in that opinion, and James is probably better positioned to talk on these kinds of issues than I am, so I'm going a little outside of my comfort circle because I'm not an academic by any stretch of the imagination, but the split in that opinion was across the board. You had Justice Sotomayor writing for the majority, you had Justice, I believe it was Jackson, concurring with Justice Gorsuch, and then you had Justice Kagan dissenting with the Chief Justice. So that sort of alignment you don't often see in today's U.S. Supreme Court.
Any more brief comments about inputs? And Patricia, you mentioned a bit about inputs in your last comment. Like, can you talk a little more about Latin America and how those are treated?
Ok. Desde Latinoamérica los problemas que tenemos son muy diferentes o los problemas, el foco central no está quizá en las regulaciones porque directamente no las tenemos y hemos hecho varias investigaciones desde la Alianza por el Acceso al Conocimiento. Primero, no existen regulaciones. O sea, no existen excepciones. Teóricamente, todo lo que está permitido en el norte, en cuanto a análisis computacional, en el sur no estaría permitido. Pero también hicimos entrevistas a investigadores y a profesionales que trabajan en el desarrollo de IA. Y su problema para ellos no es el copyright, no, porque directamente nadie lo toma en cuenta. El problema pasa por otro lado.
So when I think about the problems on inputs anyway, the issue still remains not copyright because, again, as I said, in Latin America, there are no exceptions. Is that what one considers from regulation? Therefore, all those things that can be done legally in the global north is not possible to be done in the global south. But we not just looked into the laws of the different countries. This was a research done by the Alliance, but we also interviewed several of researchers that are using methods of artificial intelligence in the region, and when they think about their concerns or talk about them, they were thinking more about any other problems but copyright. Copyright directly is not in the map of these persons that are dealing with artificial intelligence issues.
All right. We're coming close to the end of this session, so I'm going to go to the lightning round, so for short answers only. But one thing I do want to cover is, like, we've seen an explosion of AI-created works and training. Is this good for the commons or not, which I think is one of the big questions. And I'm going to give this to Teresa and then to James.
Okay, when we think about this, about AI and the commons, I think from our perspective where we are in Europe, where, as I mentioned, the EU law allows creators to exert power, so empower creators to opt out from that system where their works would be trained for generative AI with commercial purposes. So I think this creates, of course, an issue that then we would want to incentivize these people to contribute back to the commons under their own terms. So I think that's a discussion, and we had a very interesting discussion yesterday about this, that probably I think this community would benefit from having, whether it would make sense to have some sort of legal tools, protocols, to incentivize those who have opted out from commercial machine learning training to give it back again to the commons under their own terms. Because I think people right now are feeling, because they cannot control, they would preferably opt out of everything, but maybe there is an interest in still giving back to the commons and allowing some sort of uses without just opting out of everything. So I think our community, and in terms of protecting the commons, we could benefit from something that a legal tool or let's discuss that would create that incentive, because I think our tools have been always respecting and empower creators in the terms of sharing, and I think a new tool that would consider these new uses of their works and provide them with different layers of options could actually be quite beneficial for the commons.
I think that an essential piece of the success of the commons is sustainability, and a sense of reciprocity is key to that. People both contribute to the commons and draw from it. And right now, generative AI is missing some of that. People who've created works that are trained on feel that large companies are extracting those works and training on them, and then withholding the models from the commons. They're putting up proprietary apps that you have to pay expensively to use, and they don't feel like there's a return to the commons in exchange for that withdrawal. And then I'm hopeful, though, that creators using AI will start to see themselves as participants in this. Certainly, there are some people who create using AI who are very techy and like, we're going to replace artists, we don't need to hire artists anymore. But there are also people who are doing new experiments with the kinds of creative work they can make. I think of Zarya of the Dawn by Krish Kostanova as an example of a person who can realize a new creative vision because of it. And the communities of people who are experimenting with these systems, who are sharing ideas for prompts and finding new ways to create with them, like if you've seen the Spiral Village, that's an example of people who are finding emerged collaboratively. So I think there are new possibilities for collaboration that we're only just barely beginning to glimpse.
Great. And we're going to have to wrap up this session pretty soon, so I'm going to go down the line back from James to Teresa and ask, what is one thing that you want the people in this room to know about AI and the commons and your work? What is one thing that is important that we haven't covered?
AI is incredibly complicated. Whatever system you're thinking of, there are other systems that don't work that way. There are lots of players and participants, and there's going to be no one-size-fits-all solution.
Yeah, totally agree with that, James. Building off of that question that Kat just addressed and the one before it, I think the most important thing from our perspective is that copyright is not the only tool that exists for addressing problems with generative AI. We can and should be using other policy tools in our toolbox to address concerns about labor precarity, fairness, economic displacement, and those things are going to be prerequisites to having fair and just policies that allow us to coexist with AI. I think there's a ton of opportunities when we talk about the commons for artificial intelligence to move more from something that is simply privatized into something that could also be in the public sector in terms of those ideas of reciprocity. And that may change the calculus a lot for us in terms of viewing AI as something that is boosting and adding to the commons as opposed to something that is participating in new enclosure or extraction from it.
What keeps me up at night is less the known unknowns and more the unknown unknowns. And the only way, well, maybe the best way I know to deal with that is to consume and learn as much as I possibly can. And this conference is an excellent example of really not limiting myself to where I think the issues are, but casting a broad net to try and learn as much as I can from each of you, from each of these people sitting on this stage here, about what are the issues you're wrestling with. Because I'll tell you, I grew up with Terminator and Terminator 2. If we're going to outpace the machines, we got to stay ahead of them somehow.
Bien, desde el punto de vista latinoamericano, a mí me interesaría recalcar de que el desarrollo de la inteligencia artificial replica patrones coloniales que hoy tenemos un tema desde nuestros países de problemas en cuanto a mejorar el desarrollo y el impacto, de dejar de ser consumidores de algoritmos del norte, y que el tema de la falta de excepciones al derecho de autor hoy no está en el mapa, pero debería estarlo porque va a ser un problema que hoy nadie lo está tomando en cuenta, pero es un problema que va a saltar muy seguramente a futuro.
From a Latin American perspective, I would like to highlight the fact that the production or the development of artificial intelligence is replicating concerns of colonialism, in this case, data colonialism. For that purpose, then, I do believe that it is important to continue to discuss the issues of exceptions and limitations, because we need to stop being just consumers of the North algorithm to become producers. Therefore, in the coming times, the discussion on the exceptions is going to be one of the key issues to discuss too.
Yeah. So, I think I agree with Nick that when he says that this is not just a copyright issue, but this is a copyright issue as well. And this is being discussed as a copyright issue in most of the jurisdictions across the world. So it's inevitable that we discuss this within the copyright framework as well. And within this community, this is a framework that we have been working on for so many years, and our tools are copyright tools. So I would suggest that we do pay attention to the discussions from a copyright perspective and come up with perhaps some agreement on what's our position here. And I think civil society organizations should be protecting public interest activities and the public interest, and everything that's not the public interest, everything that's commercial uses, and we should be able to differentiate those. We should give agency to the creators, and I think that's part of our DNA, and right now we are not able to give that agency because our legal tools simply don't work in terms of the desired options that they would like to see there. And so if we don't do anything, from my perspective, there's a high likelihood where people opt out and they will not put a CC license just because they are afraid that would mean opting in again without defining the terms further. Thank you.
So I'd like to thank all the panelists for their knowledge and their insight. There is so much more to hear about AI, so I hope you'll go to the other sessions on specific topics throughout the conference. Thank you so much.